For the last panel of the day, we've identified a new way of looking at problems. We've listed the problems we think we have, others we don't know about yet. We've talked about the challenges of implementing reforms, and then most recently we've talked about a new process that hopefully will be studied and potentially replicated to help identify errors and near misses to permit better analysis. As our final panel of the day, and to send people off on a high note with, yeah, we think we can actually do this, we're going to talk about how researchers and practitioners can partner to test the reforms that will arise and create the sort of feedback loops and optimization of best practices that we've heard about over the course of the past day and a half. So for the panel, Successful Design of Rigorous Field Experiments in Criminal Justice, I'm happy to introduce Penn Law Professor David Abrams to moderate the panel. David is one of the leading young economists working in empirical law and economics. His work covers a range of topics tied together by the goal of understanding and measuring how individuals respond to incentives in various legal contexts. He's investigated a variety of important questions in criminal justice, including whether longer sentences actually deter crime, how the race of a defendant might impact judicial decisions, to what extent the skill of attorneys affects case outcomes, and the amount of value individuals put on freedom. His other major areas of expertise is intellectual property, where he's investigated the expected impact of the America Invents Act, the effect of patent duration on innovation, and is using natural language processing to establish more reliable measures of patent value. His work has appeared in a number of top-reviewed journals, peer-reviewed journals in law review, including the Stanford Law Review, the University of Chicago Law Review, Penn's Law Review, and the American Economic Journal. He has an AB in physics from Harvard, an MA in physics from Stanford, and a PhD in economics from MIT. So when we talk about interdisciplinary legal education, David is the embodiment of it. David?
Thanks, John. Thank you all for sticking around for the final panel, and I'll tell you what, I'm going to try to not talk too long, and I've encouraged our panel to do the same. I think we're all on board. We're going to try to make this informative, action-packed, and not too long, so we can get to lunch. But the theme of this panel is taking some of the ideas that we've talked about over the last day and a half and pushing them forward, and also putting some of them to the test rigorously. And also thinking about how do we get new ideas in the first place, how do we think about improving criminal justice, and testing those ideas in a rigorous fashion. And key to that is randomized experiments. And that's something that's going to be a theme of this panel. How do we do randomized experiments in the criminal justice world? How do we work with agencies to get that done? And this is critical if we want new ideas and proof that they work to be available to people who work in this field. And so I'm very delighted. So I got very lucky to assemble this panel of experts who've all done research using randomized or quasi-random experiments and who've worked with different criminal justice agencies. You can read their bios in here. I'm not going to read them all, but I'm happy to just introduce our panelists. James Anderson from RAND, Ann Peel from Rutgers, and Barry Scheck from the Innocence Project. I'm going to just let her rip, starting with Barry.
I don't want to pretend that I actually do the studies. The point is that we want to have studies that are done by people who really do have the scientific expertise to get them done right when you're doing studies in the field. Because field studies are so important, they're so expensive, we want to make them less expensive. We want people to engage in them more because that's really where you can eventually learn the most. We thought that I should just try as well as I could to give some history, and it's already arisen in the course of this discussion, about eyewitness identification. The one thing about eyewitness identification is that it has always had more lab studies. John Monahan always said this is the gold standard for law and social science because, recognition of somebody is a memory experiment, and you can duplicate a lot of that in the lab, and you can manipulate variables, but people have always said, quite rightly, but we really have to do that in the field, in real cases, and try to approximate as much as we could whether things that we've learned in the lab about what you've heard are like system variables, right? Things that are in control of law enforcement in the way that identifications are done versus estimator variables, which are variables that are inherent to the event or the witnesses themselves, whether it's a cross race or stress or weapons being used or the view that people have. You can manipulate those to some degree in the lab, but then when you get out in the field, you really have to try to design experiments in a rigorous way from which you can learn information. Now, historically, in 2002-2003, you might all recall that there were quite a number of exonerations and exonerations off death row. And the governor of Illinois declared a moratorium on capital punishment. But it wasn't just the moratorium on capital punishment. There were a whole series of commissions that were formed to look at much of the so-called innocence agenda of reforms that we've been just talking about, eyewitness reform, videotaping of interrogations, a whole series of things that came out of they called them the Ryan Commission panels because he was the governor. One of them on videotaping interrogations was chaired and put forward by a little-known state senator, Barack Obama, right? So the administration has always been aware and interested in these issues. Another piece of legislation that came out of the Ryan Commission reports was a delegation to the Illinois State Police to do field studies on the issue of eyewitness reform, which in theory would, at that point, out of Justice Department studies that Jim Doyle and others had a lot to do with in 1996, included reforms like giving a witness warning. The real perpetrator may not be in this photo array or lineup, to do things double blind, to take confidence statements in the words of the witness, and a whole series of best practices, all of which, by the way, IACP has long ago endorsed as training templates and has assisted in implementing in the field. However, when that first experiment was done, the project director, who I'm sure was very well intentioned, was a lawyer, right? So let me be the first to tell you, even if you think you're a really smart lawyer, you should not be the program director that's putting together a field experiment of this nature, which is not to say that it isn't helpful or useful for police officials or lawyers or others to convene and to assist and to make sure everything is going to happen. But when it comes to the experimental design, particularly when you have to get random assignment, which is really the gold standard for trying to evaluate what your results are one way or the other, you must let people like Ann and James and David be the leaders in doing the actual experimental design. Obviously, there has to be an interaction with the police in the field. You have to see what's possible or not possible to do in a responsible way. But unfortunately, what happened in the Illinois experiment is the lawyer program director took the lead, got some advice at first from some experts, but they were not there helping her to actually go into the field, talking to the police, saying exactly how are we going to do this, anticipating all the problems that can occur in these kinds of field experiments, and their job actually was just to evaluate the data later. And what happened in the Illinois study is, as many in this room know, is that on the one hand, they took double-blind sequential presentations and compared them to non-blind simultaneous presentations, which in and of itself scientifically, in subsequent review, turned out to be a confound, because you're not going to learn too much from that kind of apples and oranges comparison, much less get anything close to random assignment. Then subsequently, when the Illinois experiment was examined and Freedom of Information Acts things were done by the National Association of Criminal Defense Lawyers, and they got to look at the underlying data, all kinds of things evolved, where it turned out that in some jurisdictions, there were cases where, in the non-blind simultaneous, there were more cases where the witnesses knew the assailants than in the other condition. There were more cross-race situations. There were more cases that involved weapons and stress and other factors that would make it difficult to do comparisons that would be useful. What was even worse, however, is that, and it's because everybody was well-intentioned, this whole thing was sort of rolled out, and when it was rolled out, when it was first published, there was an article by Kate Zernike, I have to mention her name because I believe in good journalism, and this wasn't her finest moment, in the New York Times, where she just described all of this without really getting into detail about what it could be, and then all of a sudden everybody in the policing community said, aha, there's something wrong, not just with sequential versus simultaneous, there's something wrong with double-blind or blinded presentation, or the witness warnings, or the confidence, or other kinds of protections that had been put into these best practices that came out of the lab. So the baby went out with the bathwater, and if there's one thing that we, I'm sure, have all learned from these prior presentations, and that is doing reform within police departments, public defenders' offices, prosecutors, the criminal justice system in general is very, very hard. And it requires people really protecting each other, having civilized scientific conversations, and having a real meeting of the minds. Once things get into the press, and once it becomes political, you have a lot of trouble putting that genie back in the bottle. It really gets difficult to know things in a truly empirical scientific fashion. And so the Chicago study, while I posit everybody was well-intentioned, really was a problem in terms of trying to achieve reform in this area of eyewitness identification, or even begin to collect the right data. So, and you heard now we have our National Academy of Sciences looking at these best practices and the science that's being recognized by the courts. And another experiment was put forward. It took forever to get this started. Just to talk about politics, this was an experiment that the scientists in the community, including the people, Roy Malpass, who were involved in the original Illinois report, everybody got together in Greenville, South Carolina, the whole community. We realized the only way to do this, so you could achieve random assignment and get some results that everybody could begin to live with, would be to use laptop computers. And when you use the laptop computers for the identification procedure and somebody pressed a button, it could randomly assign, okay, this one is going to be sequential double-blind, and this one is going to be simultaneous double-blind, and that would be an easy and good way to do random assignment. And it seemed easy to do. We were in North Carolina. The police chief of Charlotte, North Carolina, Darrell Stevens, already was moving towards these reforms. He had his own information system, police information system, and a vendor. So this all looked easy because we could just download the pictures, from the Charlotte system. The detective, him or herself, would prepare the array using a set rule that the fillers should be based on both the description given by the witness and making sure that the suspect doesn't stand out too much, and all the best practices for giving witness warnings and taking confidence statements and everything else, and documentation would be followed. And not only that, what a rich data set we could do, because you could literally, there was a tape recording of the entire interchange between the double-blind, the administrator who didn't know the identity of the suspect, and we could literally get latencies, response latencies. We could see how long it took for somebody to make the identification. So there was all kinds of, which was a big research question everybody wanted to know about, all kinds of potential data here that looked great. And Charlotte was going to be our first big site, and we had cooperation from the police department, the prosecutors, everybody. We were going to take a look at this, and the first thing that happened soon thereafter is the Duke Lacrosse case. And as soon as the Duke Lacrosse case happened, they had all these rules in place that were just voluntary guidelines with the police about doing double-blind and sequential and all these procedures. And in the Duke Lacrosse case, they brought the complainant into the room, and they said, here's 30 pictures of all the kids that were in the fraternity house. Tell us which 3 they were, right? And as soon as that happened, and it eventually became clear that all 3 kids were innocent, and one of them, Reed Seligman, is one of my clients, so I have to say that, but it's the Attorney General of North Carolina, Roy Cooper, who used the I word and said all 3 of these kids are innocent. As soon as that happened, the legislature just said, enough of this. We don't believe in voluntary guidelines. We are mandating it, and they passed the bill. Now, I fully appreciate that the police, there's lots of ways to legislate reform, because Chris Hammond, when she got up and talked before, is exactly right. The science will change. You may want to have differences in your protocols. You can legislate, as we have in Texas, that designated agencies come up with best practices based on science, and these things can get implemented and changes. There are lots of ways to do things, but I'm just telling you what happened with our field experiment. So we had a number of things that happened in North Carolina. Boom, it got shut down. So then we went to Tucson, Arizona, to get samples, because Tucson was where the Larry Youngblood case, United States Supreme Court case, mistaken identification happened. People were very receptive, and all of a sudden we started a whole bunch of, got samples there, but then there was a breakdown between the software that we were using for getting the photos to make the photo arrays, and the stuff that we had been using out of the vendor in North Carolina, and it became really, really hard. And that was difficult, so we got some Tucson samples, but not as much as we wanted. Finally, with the help of a timely grant from John and Laura Arnold, and the heroic cooperation of Art Acevedo, the police chief in Austin, Texas, and Rose Lemberg, the district attorney, again, we went down to Austin and were able to implement this. And, you know, when a department is motivated and everybody is on board and they all feel it's important, you actually can get it done, and we got most of the samples out of Austin. Now, a few things have to be said about how all this happened in terms of the lab versus the field tests, field experiments, and what you can learn. Before the actual screens that were used for the laptop computers and the questions being asked back and forth to the witnesses were derived, there were discussions, not just with the people that were going to do it in Charlotte, North Carolina, or Tucson, or San Diego, but the scientific team, as well as yours truly, one of the lawyers and the people from the Police Foundation and John Jay School of Criminal Justice, we visited at length with police officials in Dallas, Texas, who are doing these reforms. We talk with people in St. Louis. We talk with people in Florida. I'm blanking on there must have been about 10 or 11 different jurisdictions where we actually went and said, would this work for you? What's wrong, if anything, with how this implements? Because we want to make sure that it works and it gets the questions right and you will like it. But at the same time, we'll achieve random assignment and we'll get useful results. So some of the things that happened are interesting. The first is that the way that sequential identification procedures are done in the field are different from the way they're done in the lab. The way they're done in the field is that if the witness asks, once you tell them, we're going to show you quite a number of pictures in this experiment, and in the field usually you don't tell them how many, you just tell them, even if you see somebody that you recognize, we're going to show you more pictures after that, but you don't tell them how many you're going to show them, okay? But once the witness goes through and has seen all the pictures, if the witness says, I want to look again and do a second lap, you allow the witness to go back and do a second lap. Now, that kind of experimentation wasn't done in the lab because the whole issue between simultaneous versus sequential is that in the simultaneous condition, witnesses can make relative judgments, and in the sequential, they don't make relative judgments. They're looking each individually, and that is supposed to be the demonstrated that people do make relative judgments simultaneous, no question about it. But this issue was one of the scientific, it's the main variable that was being manipulated. So how can you let them go back a second time? Because when you let them go back a second time, they're going to be engaging in some kind of relative judgment. But the truth is that police in the field, right, they said, we're not going to do this unless, if the witness is telling me that they saw somebody that they think might be the person, I'm going to give them a second lap. I can't do the investigation any other way. What you do in the lab is one thing. So that is the way from the beginning, whether it was in New Jersey that mandated sequential all the way back in 1999, and sequential double-blind's been doing this now for, I think I mentioned something about it, but I guess now we can say 15 years, right? They always did it that way. Another thing, the police, it's very important scientifically to get a confidence statement from the witness at the time of the identification. If there's anything that is going to even mildly correlate with reliability, it's the confidence statement at the time of the identification. In the lab, what scientists want is to get a confidence statement on a scale of 1 to 100, right? They want a numerical confidence statement. And what my friend Chris Hammond was talking about before in terms of new research with respect to sequential versus simultaneous, a scientist named Wickstead and colleagues have been doing what they call ROC curves, looking at the trade-offs that you get with simultaneous versus sequential. But the key variable in their ROC curves is confidence. He's modeling this curve based on confidence. So Wickstead, if you asked him, would say, yes, I see an advantage here for simultaneous, but I'm basing it on a confidence statement of 1 to 100, right? So that's what the scientist is saying. And then I say to him, well, look, people like Chris and I, we can't tell police officers, take a confidence statement and give me a number, right? In fact, what police have always insisted, and I agree with them, is that when they take a confidence statement, they say, tell me in your own words how certain or sure are you, but don't give me a number and don't give me a percentage. And the reason that the lawyers say don't give me a number or percentage is, I'm sorry? Well, or a very, very strong statement. The reason that people don't want that is police don't want that, they've told us, again and again in all these sessions, is that if somebody were to say, I'm 90% sure, no, that's probably pretty sure, but to a jury that sounds like a reasonable doubt, and a prosecutor ordinarily doesn't want a number or statistic. So we went and did this with a number of variations from what was done in the lab. Now, interestingly, the results of this, which are just been accepted for publication in Law and Human Behavior in February, but people have seen these results before, is that when you have that second lap, right, with sequential, you get pretty similar number of suspect picks with the sequential double-blind as you do with the simultaneous double-blind, whereas ordinarily the prediction would have been that you would have gotten fewer statements with the sequential double-blind, fewer suspect picks, I'm sorry, which you'll see it's discussed at length in this paper, is interesting because now this means that they're going to have to go back to the lab and allow second laps and see to what extent this changes anything. It did reduce, however, filler picks, which has, for reasons that I think somebody talked about before, about burned witnesses, is an advantage for police. So having said all of that, I commend your attention to this field study. It did achieve random assignment. We also followed up on, it wasn't enough just to have random assignment, which we got by the laptop. Other controls were built into this experiment where information was systematically collected on race, on opportunity to observe, on whether weapons were used, and how long between the time of the incident and the identification, because those other factors also can affect the data. Even though you have achieved random assignment, you want to put other controls in place to help. So whether people ultimately decide to go with double-blind sequential or double-blind simultaneous, it's always been the Innocence Project's position that that is a decision that police departments will make on on themselves based on policy decisions. We probably have a preference, but that is a discretionary kind of thing. But what's really important is that everything that's in this study, right, is rigorously collected, documented. You can see all the pictures, you can see all the data. There's not any black holes in it in that respect, and it's something that whether the results stand or fall or change the way people do it, we can learn from this because a lot of rigor and scientific controls were put into it. Of course, it took 6 or 7 years to get done. Hopefully, we could do these things faster.
But it was worth it. Thanks, Barry. Ann Peel is going to talk next.
So thank you very much. Jim Doyle pointed out the challenge of saying something new at this point in the conference. So what I thought I would talk about today is a bit of time series econometrics. Right? So we'll see how that goes, just a little bit. All right, so before I get to that, let me talk more generally about evaluation of field experiments, following on the setup that Barry provided. Field experiments test an idea or pilot an initiative, usually. And we've come up with a lot of ideas and a lot of hypotheses over the last day and a half. And some of these have been tested and many of them haven't been rigorously tested. So an evaluation of these ideas would assess the impacts and facilitate the generalization of knowledge, okay? And to me, that's really what we want to do is part of, or what the Quattrone Center really wants to do, is try to generalize the knowledge that people are producing in their day-to-day life in a way that we can spread best practices and spread them much more rapidly. Now, both David and Barry talked about randomization as the gold standard for evaluation, and that's true. It's the way that evaluation is frequently discussed. It uses the random assignment of any given participant to either the treatment condition or the control condition, so that the controls serve as a measure of the counterfactual, what would have happened to the treatment group if it hadn't been treated, right? So random assignment, why we care about randomization, is to make sure that there's no manipulation of the process by either the researcher or the participant. who wants to select into one condition or another. And another reason that we really like it is that the results are easy to communicate, right? It either goes up or goes down, treatment versus control. You can kind of report the results by measuring means or percentages, and that's very useful in terms of spreading knowledge. But there are some concerns about our ability to implement a clean random assignment experiment in practice. Barry talked about some of them in terms of, you can have technological breakdown or political intervention, et cetera, but also in a lot of cases in more complicated kind of treatments, there is some cross-contamination or manipulation. If you're in a reentry program and you see that some people are getting services that you're not, you show up at their site the next day, for example. There are lots of cases in which it's hard to ensure that the random assignment takes place over time when you're doing something that's more complicated or involved. And in fact, in the economics literature, there's very, very contentious debate about randomization. Is that the gold standard or not? I'm not going to get into that debate, but it's fun to watch. So what are some barriers to randomized field trials? One I want to mention is the human subjects protections. Okay, so if you work for an agency here and you're interested in working with outside researchers on a research project, I think there are lots of upsides, and I want to leave with the idea that it would be great to work with outside researchers to evaluate ideas. But one of the major downside of working with outsiders is that we then bring with us these responsibilities for human subjects protections that an agency might not have in considering doing some evaluation on their own. And the protections of human subjects the threshold for protection is much higher for those accused of crimes than for citizens when you're not thinking about something that might affect the probability that their liberty is curtailed in some way. Another barrier to random assignment is if the initiative is system-wide, right? A lot of the things that we were talking about in the earlier sessions today, we're thinking about changing the whole culture of an institution. If it's system-wide, you can't really randomly assign some groups to change their culture and some not, if the idea is inherently system-wide. And even if you could, you might have spillovers from one group to another, which would then contaminate the random assignment and make it have been an unnecessary bit of effort. Finally, agencies are often uninterested in doing random assignment for particular reasons. There might be just some inherent management leadership reason that they really feel that it's unacceptable to engage in such an experimental kind of design. And finally, if you had a system-wide event, I'll talk about this in a minute, but if you had a system-wide intervention, you might think about using other jurisdictions as the counterfactuals, but we've all talked about and we all know that the vast differences from one jurisdiction to another so that there can be complicated, that cannot necessarily be an easy solution. So in these cases, when you can't randomize, what can we do? So I want to spend just a couple of minutes talking about evaluation that I was involved with a project that started in 1995 in Boston, which was an initiative, a complicated collaboration across many participants to address the problem of youth homicide. Okay, it's a little bit tangential to some of the key issues that we are talking about of conviction and wrongful conviction and mistakes and processes here today, but the lessons for evaluation, I think, should be clear. All right, so this began in 1995. It was conceived of as a test of the broad hypothesis that if you research a problem initially, that will possibly result in intervention, ideas, tactics, and strategies that you might not have arrived at without conducting the research at the beginning. And then the idea was to evaluate it. Now, this was funded by the National Institute of Justice and with a very kind of open-minded initial idea about what the tactical and strategic intervention would be. We passed the human subjects hurdle on this, but the other hurdles remained. Right, so let me just show you a couple of reasons why a random assignment was not going to work, in addition to lack of interest by the police and prosecutors involved, and the social workers working out of the mayor's office. All right. So, just a quick map of Boston. This is just a pin map of the locations, the geographic locations of the youth homicides that had happened in the immediate prior period. There's not, very concentrated. I mean, a lot of what we work on in criminal justice, there's a concentration, demographic or geographic. Wasn't really possible to set out certain areas as control areas. In other functions of policing, there have been randomized assignments. For example, if you're looking at drug markets, you might be able to do something where you have many more units of analysis that you could imagine setting aside as controls, but not true if your outcome is quite concentrated. Another reason is that one of the important vectors of the problem that we identified from some of the early on research was that gang relationships was an important part of the process generating these homicide victimizations. And so the idea would be if you could influence one gang, that would have spillovers, and that it was purposefully to have spillovers. So another reason why you couldn't really set aside certain parts of the city or certain subgroups as untreated and certain as treated. So I'm not going to go through the details of the evaluation results or of the intervention, but just let me summarize. There was only one site. Another common thing in an intervention, especially if it's a kind of a first stage initiative, is that the strategy evolved over time. So not always clear exactly what's the start point. Very different, kind of more complex intervention than the witness identification idea that Barry was just talking about. And as I said earlier, there's a premise, and I think that we had, and that is true in a lot of cases, that local conditions are going to matter, keeps you from using other cities as tight controls. All right, and then finally, the evaluation design, really didn't precede the policy development because this kind of evolved. So what do we do? What we wanted to do was a variation on a pre-post design, called it interrupted time series. This is where we get to the time series econometrics. And we could do something a little fancier, though, than a simple pre-post, because one of the things that you worry about when people tell you what happened after minus what happened before is that they chose the date to call the difference between the after and the before to maximize that gap, all right? And especially if you're a researcher that's involved in what's going on in some ways with the intervention, you want to be as transparent as possible, hands above the table, and make this as transparent as possible to other people, in part because that's just responsible, but also we want to know the right answer if this is effective or not, so that we're not overly optimistic in our conclusions, assume something works, export it, generalize it, etc., and use our precious resources on something that's not actually effective. So in order to, there's some statistical things that you can do that we adapted from the literature to protect yourself on being overly biased by retroactively deciding when the start date must have been from your intervention, because that's where it maximizes the estimated effect. And the other things that you can do is, as Barry suggested at the end of his talk, is control for other factors that are trending at the same time. And one thing that economists have really taken quite a liking to recently is something we call placebo tests, with, again, the analogy to the medical design, come up with something else that should not have been affected in the same way, at the same time as the thing you hypothesized was affected. Use your same design to run against that set of data, and if you're right that your policy had an impact, you should not find it applying your design where you don't expect to find it. So that's very useful, again, for being transparent and hands above the table. So what are some of the practical lessons? I already told you the downside. I didn't put that on my concluding slide. The downside of having outside researchers is that it might slow things down if they need to get human subjects approval from their own institution. One of the upsides is that the data needed for the initiative often overlapped with those for the evaluation, so there's often not much additional cost. And if you bring an evaluator in, a lot of times that person can help bring outside resources in from governmental or non-governmental funders in order to provide some of the revenue for certainly the evaluation, but also sometimes some of the implementation of a pilot or a replication. Evaluation might have to adapt to the changing implementation requirements, so there's a lot of benefit to close communication between researchers and those who are actually implementing whatever it is that you're testing. And as James is going to talk about in more detail, sometimes the odd quirks that happen in implementation, like you can't roll it all out at once, for example, turn out to give you opportunities for evaluation, because if something rolls out over time, then you can do some fancier kind of statistical analyses to take advantage of that for identification. And then the last thing I guess I would say is that, we've already talked about transparency, I think that's obvious, but evaluations for replications might be very different than evaluations for something that you're setting up as a pilot kind of program. In the replication, you might have a much cleaner idea of what it is exactly that you're testing, have a clear start date, and you can use some different designs under those kind of conditions. Thanks.
Great. Thanks, Ann. James, you get to be the final speaker of the conference.
Thanks, David. Really, first, I want to join everyone else in thanking Frank and Denise and John for this tremendous conference. And I thought I'd begin by telling a very quick war story. Before I became a researcher and joined RAND, I was an assistant federal defender actually here in Philadelphia and represented death row clients, and was tangentially involved in an exoneration that our office handled. And one of the things that was striking about that experience to me was how indistinguishable the client that turned out to be completely innocent was from our perspective from all the other clients. So that there was no sort of like, coming into this from a very naive perspective, I sort of thought, there'd be some obvious signs of innocence. And this particular client would seem particularly innocent somehow. And that really wasn't the case. And that experience definitely struck me and also made me want to think hard about ways to really improve the fundamental reliability of the criminal justice system, and that the enormous need for doing precisely that. And I think this conference is a terrific first step at doing that. So to segue from that introduction to what I'm going to talk about now is I'm going to talk a little bit about the way that, as one of the ways of sort of measuring things in the criminal justice system, is by using natural experiments and sort of taking advantage of variation when it occurs to try to do what we try to do in social science, which is causal inference, try to make valid inference about the causes or the effects of some sort of policy or treatment that you apply. So the first, to build on what Ann was saying, measuring the counterfactual is kind of the key goal, and it sounds sort of technical, but the intuition is really you're just trying to figure out what would have happened absent the treatment. And so what in the criminal justice thing, if you're trying to improve things by rolling out a new policy, you want to find out what would have happened absent the treatment. And a field experiment uses random assignment to ensure the treated group and the untreated group are identical, and that you don't have to use fancy math to sort of control for different things that where the groups might vary. And really, the natural experiment tries to do the same thing, but you're just sort of taking advantage of a variation that already occurs because of some variation in the way that a policy was rolled out or implemented. The two approaches sort of have different advantages and disadvantages. With a field experiment advantage, you kind of have more control of the assignment mechanism, whereas a natural experiment, you're more sort of stuck with how the randomization occurred. Now, this is important, and it goes back to a couple of points that both David and Ann made, that a strong research design usually sort of trumps a fancy technique. And so it's always better when you're trying to make any kind of causal conclusions, is to design the research up front and have control over the research. You can draw stronger statistical conclusions, but maybe even more importantly, particularly in this context, is it's a lot easier to explain to audiences who aren't necessarily statistically sophisticated. And one of the great advantages of sort of experimental design is you can, and again, building on what Ann said, you can really explain it and say, look, this group ended up here, this group ended up here. Well, maybe we want to go with, with group A. Now, there are also some important disadvantages that Ann talked a little bit about as well. Getting cooperation from the agency for random assignments can be hard. People by and large don't like to be guinea pigs. So if you are trying to implement a potential reform and talk about it in this way, you could certainly get resistance. And also that subjects who are aware of an experiment and have a vested interest in either doing things the way that they wanted to do it or the way before, or vice versa, may act differently. So you have some concern about bias in results if the subjects are aware of the experiment, which normally they would have to be to get informed consent consistent with the human subject protection. Natural experiment certainly has its advantages and addresses some of those issues. The power is often very large, which means you have a very, very high number of people involved, because often this wasn't intended as an experiment. And that allows you to detect relatively small differences in outcomes. And because the study is retrospective, you don't have to worry about the knowledge of the study biasing any subject's reactions. And it's also, again, going back to the point that it's easier for non-experts to understand if you just, again, there's something sort of intuitively obvious about it. So I'm going to talk briefly, but I did want to talk about some of the disadvantages. They're harder to find, right? So you have to be more sensitive to finding and taking advantage of natural experiments when they occur. And it's sort of harder to start with the policy and say, well, we want to test this, and then look around for a natural experiment. It's easier to sort of be sensitive to the existence of the natural experiment and try to take advantage of it to address some issue that you're interested in. The other key thing is, and I'll talk about that in the context of a couple examples, is you really have to understand the random assignment mechanism. Because often lay people sort of confuse the term random, meaning sort of independence of outcomes, with a definition of sort of haphazard, which sort of means, well, it just seems like it's all over the map. And that's a very important distinction if you're going to draw statistically valid conclusions. And then finally, the last disadvantage I'm just going to touch on very briefly is that sometimes you'll get imperfect compliance. So, and what that sort of means is that if a subject was originally assigned to one group but then crossed over and ended up being treated as if they were in the other group, how do you deal with that? And the answer is there's a particular statistical approach called an instrumental variables approach that allows you to address that quite elegantly. It does have some disadvantages and complicates things a little bit, but not that much, and it's also relatively intuitively easy to understand. All right, so I'm going to talk about two brief examples of studies where we were able to take advantage of this natural experiment. One was to look at the question of interjudge sentencing disparity. The Federal Sentencing Reform Act of 1984, one of the kind of key goals of it was to reduce interjudge sentencing disparity. What's interjudge sentencing disparity? Well, it's if you get sentenced by sort of Judge A, that you get substantially longer sentences than if you get sentenced by Judge B. There's, as far as I know, virtually no theory of criminal justice where this would be a good thing. Everyone pretty much thinks it's a bad thing, and one of the goals of the Sentencing Reform Act was to try to eliminate it. But it turns out it was a little bit difficult to measure. We used the random assignment of judges to criminal cases within a district to measure the extent of interjudge sentencing disparity before and after the sentencing guidelines. Well, that sounded pretty straightforward, and I thought it was going to be really straightforward. I was in law school and read an article by Joel Waldfogel who did this, and thought it'd be really pretty easy. You just get the data and do it. Well, it turned out there were a bunch of complications, and it was actually much longer and more complicated than I thought it was going to be. One was to ensure that the case assignment was actually random. This goes back to the point I made before. So I called up every district in the country and talked to the clerk. And sometimes you get somebody on the phone and be like, "Oh yeah, that random assignment's completely random. The chief judge just assigns it to whoever he wants." And then we were like, "Oh, all right, we can't use that district." And there was sort of these different variations of and different definitions and different understandings of random. And ultimately, the project didn't require some fancy math to do the comparisons, but the sort of core design was intuitively understandable, which is and relatively simple. Is that you're really just trying to figure out and compare the amount of interjudge sentencing disparity before and after this policy change. So what the results? I'm not going to go into them, but the sentencing guidelines did reduce interjudge sentencing disparity, somewhat, from 17% to 11%. And there's the site in case anybody's interested. The second project I'm going to talk about real quick actually occurred here in Philadelphia. The research question was really sort of how much difference does a lawyer make to the outcome of serious cases? David did some great work on this earlier. We took advantage of this sort of wonderful natural experiment where 20% of serious homicide cases in Philadelphia were assigned to the public defender's office, whereas 80% were assigned to appointed lawyers. And from a systems approach, you like to believe that, particularly in the most serious cases, the kind of lawyer you'd get shouldn't make that much difference. I mean, at least, I mean, we all sort of know that that's probably not the case. And I don't want to give away the results, but at least from a sort of pure theoretical perspective, you would like to design a system that's robust enough to the vagaries of human error, and the quality of human, the input into counsel, that it wouldn't make that much difference. And unfortunately, of course, that's not the case. But anyway, well, here's the murder case processing system in Philadelphia. I don't want to get into too many of the details, but sort of the core randomization. Whoops! Oh shoot! That we're trying to take advantage of. There we go. Was sort of here. In the preliminary arraignment, the randomization occurred at that point. 4 of the cases went to appointed private counsel. For every 1 case that went to the Defender Association. What could possibly go wrong? The sort of key methodological issue was post-assignment non-random crossover. And so to use this nifty pointer, this occurred here. So while we were very confident that this was genuinely random, what was happening here caused us to have some concerns. The Defender Association would lose some cases because they were conflicted out. They would get replacement cases before they actually went to the appointed private counsel, but when they were still in the court administration system. But it wasn't clear at all that these were random. What do you do in a situation like that? You use this instrumental variable technique, where essentially what it allows you to do is when you get down to the final outcomes, the verdict and sentencing, it allows you to essentially attribute the portion of that variation that's attributable to the initial random assignment. So it essentially allows you to control for the fact that you may have had non-random post-assignment crossover. And it sort of sounds complex, but the intuition is that you're just using the part of the variation that you know was originally attributable to the random assignment. What were the results? The Defender Association provided much better defense. Murder conviction rate was about 19% lower. Life sentence rate was lower, and the overall expected time served was quite a bit shorter. A nice demonstration of how far we are from the vision of this sort of world where the system's robust enough so that the particular quality of the lawyer wouldn't make much difference to the outcomes. So what are sort of the overall takeaway conclusions? First, experiments in both natural and field are strong research designs for a lot of the reasons that David and Ann pointed out. The key goal is to sort of measure the counterfactual, and these are good ways of trying to do that. They're also, by and large, easily understandable by policymakers. I think that's really important, obviously, if you're trying to accomplish any kind of policy change. A couple caveats. One, the researchers really have to understand the assignment mechanisms really well. At least when I went to the interjudge sentencing disparity, I thought piece of cake. Federal judges are assigned randomly in districts. I talked to them. They seem to say they're assigned randomly, but then actually digging in and realizing that they're non-random. Same thing with the Philly study. If we hadn't accounted for the post-assignment crossover and the non-randomness of that, the findings wouldn't be valid. And then the practitioners, have to sort of understand some of the statistical complexities if you're trying to do this. And sort of the final note I want to make is the fact that even in this area, there's just not a lot of replication. So, in a mature scientific field, you don't have just a handful of research out there trying to draw conclusions to this. You have departments, and you have all the sort of major findings of a field replicated again and again and again. And we're still pretty far from that. Thank you very much.
Thanks a lot, James, and thanks very much for all of our panelists. And by the way, those are two outstanding studies which I cite all the time. Okay, so we've got some time for questions. I'm going to ask one. I've got one that I'd like to ask, but let me first ask. Let me ask. I think we have one of our exonerees.
Yes.
With a question. Michael Morton.
Okay. First of all, Frank and Denise, thank you. This has been great. Superb stuff. And good job, John. My name is Michael Morton, and I'm one of the exonerees to continue this pattern we started today. When I was 32 years old, my wife was murdered in our bed, and I was convicted of it. And when I was 57, after 24 years and 7 months to the day, I got out. Thank you, Barry. DNA exoneration. And one of the things that we discovered in all of this was that mine wasn't bad witness identification or anything like that, but it was misconduct. It was Brady stuff. The prosecutor hid exculpatory evidence. And my question is, with the way that this symposium has gone, we've gone from this theoretical base yesterday, and we're coming around to the practical, what's real and what we can do now. My question for the panel is, what sort of studies we can do, or what sort of experiments can we do in the field to look at something like this, prosecutorial misconduct? Because in a fair number of these cases, somebody is always doing something wrong. There is a bad actor. While it's been said many times, nobody here or nobody around wants to convict an innocent person. I think most of your exonerees will just say, duh. But there are bad actors on both sides of the line. And so I wonder, is there anything that this panel can think of that would actually test for this or put this in an experimental realm?
The short answer is no. The slightly more nuanced answer is I think the current regime of Brady requires prosecutors to make very difficult decisions, or allows them maybe to make very difficult decisions about. And I think, Stephanos, haven't you written on this? And it seems pretty indefensible to me. So I mean, that's not an experiment. Obviously, that's a suggested policy reform that I think would be supported by existing psychological experimental evidence on how difficult it is to evaluate whether any given piece of evidence constitutes material evidence. Now, I mean, clearly there's some black and white cases like your own. Where it's hard to imagine any conceivable rationale for not disclosing the evidence that was concealed in your case. But in a lot of cases, one sees, and when I did post-conviction work, you saw sort of convoluted justifications, ad hoc justifications for, well, we didn't disclose this because by itself, and then we didn't disclose this because by itself, and blah, 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 blah. And it was at least it sometimes was able to find judges who agreed with it.
I think, go ahead, I'm saying,
go
ahead. No, I'm much more interested in what you have to say.
No, I think this is a really an excellent question that you've posed. It's really fascinating because you're right, we haven't talked about experiments or initiatives to kind of pilot and think about that particular question. And in fact, the people who spoke to us yesterday from other fields kind of suggested that if you work on the processes for the good apples, that makes the bad apples kind of more apparent, right? So that's kind of the way I was thinking about this. But your question is very provocative because there's so little we know about what goes on within district attorneys' offices from a kind of academic research perspective. We know a lot more about policing and police organizations and police reform, even though we all agree that's too little, right? But we know a lot more in that field than in district attorneys' offices. And one of the things that I've noticed is that increasing reference to policy guidelines and trainings and that kind of thing within DA's offices, but they're very private and not open for study. So I think it's a provocative question. I think it's a good challenge to all of us to think about designing particular initiatives around, are there ways that we could measure and then also think about testing what certain training and policies and audits, checklists, et cetera, might do to that kind of treatment of evidence. So thank you very much for the question.
Thank you. Lots of different experiments, some natural, now that you put it out there, occur. One thing, though, is the rule in 49 states, the District of Columbia and Guam, the ethical rule, and it's rule that the New York District Attorneys Association, I know, has adopted and follows, is that prosecutors are supposed to turn over all evidence that, quote, tends to negate guilt or mitigate punishment, which is independent and broader than Brady. Now, that's the law. The ethical rule is the law. So there's a number of things one can think about in terms of, just doing experiments with prosecutors. If you actually ask them to live up to that statement, you could do a quick random sample with some test case to see if that particular standard, if actually they're asked to evaluate a case file in some training class or some set of supervisors, does that make a difference in terms of what they'll disclose versus the traditional rule that some mistakenly believe is the only rule for prospective disclosure, and that is the information going to be considered, quote, material or very important by some appellate judge if it's ever discovered after a trial that has not yet happened. Right? That's one kind of set of experiments. Another kind of retroactive analysis that I know the Veritas Initiative is approached, when you begin looking at cases where there has been a failure to disclose, right, is it really the prosecutor that failed to disclose? Or was it in fact, the police that didn't turn over the documents to the prosecutor? And is there anything that one can systematically figure out to make sure that that doesn't happen? Is there some systematic way to make sure that people look at, a prosecutor has his or her file, it may be a homicide or a narcotics case or some other kind of case, and the question is, do they look at the police file, and is there some rule in place that they look at the police file? So if you had, let's say, random assignment of some set of prosecutors that were required to look at the underlying police file versus those that had the option of doing it in some particular jurisdiction, would there be more disclosures? Frankly, I can make up a lot of these, all of which are very interesting and can be comparatively rigorous when we begin to think about them. And I could go on. But thank you. Who was that guy that asked that question? Thank you. Thank you very much for everything you do.
Thanks for all great answers. I would add one more thing. This is not exactly on the panel, but another thing on the panel topic, but another idea might be if we can get comparable data from many jurisdictions, you can see it'd be hard to, it wouldn't detect in an individual case, but you could start seeing patterns and you could start see where one jurisdiction has a series of, let's say, anomalies. That can stand out when you get data that's comparable across jurisdictions. And there are efforts, Measures for Justice is one place that's trying to start doing this in a systematic way, collecting more data to, and we're partnering with them to try to help allow that possibility. But that beyond all these great experimental ideas.
One thing I should give credit to the Jefferson Parish District Attorney's Office got the Orleans Parish District Attorney's Office to conduct a joint exercise with the Innocence Project in New Orleans and the Defense Bar, where they had people reverse roles so that the defense lawyers played the prosecutors and the prosecutors played the defense lawyers on a set of cases, and then they figured out who would disclose what, and it was a very interesting set of results. I don't know if they systematically collected that. I mean, it was a group process that's kind of a traditional thing that we do in law schools as clinicians, or people do simulations, role playing. But that actually, from what everybody said, it was pretty interesting.
Is there anything published on that?
It's funny, the person that organized that for the New Orleans Innocence Project is now a lawyer in the Civil Rights Division of the Department of Justice, so I'm going to have to go ask him about it, but it was a pretty good idea, I thought.
Okay, we're building up a bit of a line.
Yeah, Lee Fleischer from the other fields, medicine. So, and I apologize, I missed part of Barry's talk. We are beginning to question our own evidence. As we accumulate evidence, many of us are writing papers on what is evidence. There's something called Bayes' theorem, which says your prior beliefs are going to influence how you interpret a study. And if you really believe something's true, we've seen this over and over again, we go and we adopt something that, one study, 200 people, 400 people, even 1,000 people, we adopt it, and then 10, 15 years later, we found out it doesn't work. You're at a different stage than we are. We're still using instrumental variables also, but as you start looking, we've now adopted an entire science called implementation science to look at the sociology of how we take that evidence and see if it makes a difference. And we actually have sociologists working alongside us to see when we adopt it into a new setting, will it work? How's that going to work in law? I mean, as you try to do what we've done for the last 100 years and begin to now question ourselves, we've actually one of my colleagues looked at recommendations that came out of national bodies and how frequently they're downgraded. And it's like 20%, where they used to say, this is what you got to do, like for hormone replacement therapy, and all of a sudden we say, whoops, that the unintended consequences when we adopt it nationally will have bad results. So I'm just wondering how you're thinking about that.
Well, it's even worse in the criminal justice system. Jim brought up before the mammogram, right? Well, one of the great differences between the criminal justice system in this area and medicine is that in medicine, if you look at an image, right, and you make an assessment, that looks like a tumor, I think it's going to be, malignant or benign. Well, you cut somebody open and you take a look and you find out the answer, right? Or you have a particular therapeutic protocol and then you see what the results are. In the criminal justice system, one of our big problems is in terms of the feedback, we don't know ground truth, right? That's one of the things. So that compounds the problem. But, I very much take your point. I mean, the interesting thing about the mammogram now is I suppose that's something where everybody's clear. You can do an ROC curve, right? And you can make an assessment about, true and false hits and whether or not it really makes sense to have one of these things given the other consequences. That is going to be a little bit more of a problem in the criminal justice field. So, but your point is exactly right.
Well, I was just saying real briefly, I mean, I think that's an excellent point. I mean, you also have to realize that, all the work that we do, we're going to clearly get some things wrong on the specifics, right? But the point is to introduce not that you should do X or Y or Z, it's that X or Y or Z may change, but you need to be cognizant of the best practices. And the best practices are necessarily going to change, but that's okay. And I think it is important politically not to get wedded to, well, what we're really about is recommending concrete change X, if it's possible that the concrete change X may change over time, which it surely will.
But I just would be very careful about your biases. Because I just lived through one, and how people adopted something because they so believed that it had to work. Yeah. And when we finally did the large trial, others did it 2 years ago, it didn't. But the beliefs is what the problem was.
Not only the beliefs, but also just the practicalities of implementing one of these programs. It often gets done under a leader who's fairly progressive and open to change, right? Otherwise, it can't get implemented. And so if we extrapolate and generalize that to the other 3,000 counties that didn't sign up to be the first on their block to try it, we can also have too much optimism there.
Okay. Frank.
I'd like to thank these panelists and want to follow up on Michael's very good question and take advantage of the fact that we have three distinguished economists, plus Barry, on the panel, and reframe Michael's question a little bit, because I think that the real issue is every profession, I believe, has 99% of its people who are good, upstanding, always want to do the right thing, and maybe 1% of people who might be tempted to go over to the dark side. And that there are, in most industries, balanced incentives for people to take the risk of cheating for the reward. And I think, based on my personal observations and experience, that for prosecutors, they have skewed incentives to cheat. And by that, I mean that the economic rewards or political rewards for cheating and winning are more extreme than they are in some professions, yet the consequences of cheating and getting caught are not quite as severe because, as Barry mentioned, they have absolute immunity from lawsuit. And as Barry also mentioned in a study that was done by the Northern California Innocence Project, that prosecutors are rarely even identified by name, let alone punished when they are found to have engaged in misconduct. And so I would like to challenge the economists who know a lot about the law to see if you could study somehow whether these skewed incentives lead to more of a temptation to commit Brady violations. And even though it's a very small number of the profession that does this, it has huge consequences on fine human beings like Michael. And I think that we owe it to him and his fellow exonerees to study that kind of a problem. So I know, Ann, you've done some research on prosecutorial incentives to some extent on a slightly different topic, but I'd like to see if you all have any thoughts on that.
Well, no, we talked about this briefly yesterday. I think it's a very interesting research idea. I haven't thought of exactly a place where you might implement it. I think, the obvious places to look might be comparatively across different countries where we have different legal regimes in terms of what the incentives are for different groups. But I haven't done any of that work myself.
Well, and I just, to make the obvious point that the sort of the cultural narrative about innocence has shifted enormously, thanks a lot to Barry's work and other groups like that. 15 years ago, right, this didn't seem to be so much of a problem. And that cultural narrative is really important because it controls the sort of political costs and benefits to a particular DA. And so if you can change the cultural narrative, ideally you also change the benefits and the cost to an individual, presumably politically accountable district attorney and ultimately police.
So I'll say one thing that occurred to me when you mentioned this immediately is what I think is a good analogy, and that's CEOs. CEO compensation is also one that we think promotes risk-taking, partly intentionally, but partly perhaps to too great an extent. And that's something that's certainly been researched in corporate finance a good deal. I don't, and I dabble in that a little bit, and I can't think of right now a study that has tried to systematically look at as incentives for CEOs have been ratcheted up if we see kind of more malfeasance, but also just more, another bad outcome, maybe not as bad as some of the criminal context, but bankruptcy. Do you take big risks with a company and invest in projects that have potential high payoff, but potentially can sink the company? And possibly, and certainly some people have argued, that this is partially responsible for the 2008 financial crisis. So people have definitely been thinking about how asymmetric incentives can lead to pernicious outcomes in this, what I think might be an interesting analogous setting. And it's something that we should probably try to carry over, I think, to the criminal justice more.
Do you think that with what you just talked about, would there be more fraud or less if CEOs were never thrown in jail for it, or if plaintiffs,
Right.
attorneys couldn't sue them for it?
Yeah, exactly. Yeah, no, so clearly the structure of the compensation matters, and also so does the potential downside risk. Yeah.
And I think there has been some research on the relationship between district attorneys seeking the death penalty and election cycles. I don't know the site off the top of my head, but somebody here probably does.
Yeah, it's the broken system study. There's a bunch of studies on that, where they took a look at counties, because counties are really important. Each, just as we know, in terms of rule breaking, whether it's a particular homicide department of police may go bad and become rule breakers. Counties can overproduce certain problems like that. And I think in the Fagan-Liebman study, they had political factors that were correlated with death sentences.
Okay, Jeff.
Yeah, thank you. One of the most pervasive barriers to the fair administration of justice is race and racial prejudice. And we know, there's been tons of research that shows from every stage in a criminal proceeding, whether it's a stop and frisk, a detention, an arrest, a traffic stop, the charging, the criminal process itself, the setting of bail, decisions that are made at a preliminary hearing, the trial, the jury process, the involvement of the prosecutor, even the defender, and the views that the defender may have towards his or her client. All those things impact the outcome in a case. And when we're talking about misconduct, we're presuming the person is aware of it on some level, that there's some conscious awareness that they're engaging in something they shouldn't. Whereas when it comes to race bias, the person's not aware of it. And so my question for you as researchers, and I know there's been some good research done and around this issue, the IAT, for example, the implicit association test. They recently did a study that showed that judges who were asked to sentence defendants, as the skin color of the defendants got darker, the sentences increased. It's something that they were completely unaware of. The good news was that judges who were told that they were being monitored by a group that was studying racial outcomes in cases actually adjusted their sentences to correct them. But I was just wondering, what solution do you have, or would you posit as researchers to this? In my office, we have a racial justice committee. We're starting to look and breaking down charges and looking at disproportionate results in those cases. But I'm very interested to know, as researchers, what you would posit as to not only getting the research out there. I think we have enough research, but how we can use the research to, change the way in which, defenders, prosecutors, judges, police officers make these judgments in cases that affect the outcomes.
I'm going to jump in and answer the first part of the question, and then leave the second to the rest of the esteemed panel, because I've done some work on this myself. And I'll say it's a really tough question. A lot of people have tried to work on it, but the fundamental difficulty, and this is perfectly in keeping with the theme of our panel, is that you can't randomly assign race. So then how do you figure out whether there's a racial effect or some other effect? Because oftentimes minorities not only are minority and identifiable as such, but are also of lower socioeconomic status, might live in different areas. And how do you separate those things out? It's hard. In general, and you try to look for things like were mentioned in the panel, use techniques like instrumental variables, and you look, and sometimes you use, say, random assignment of cases to judges, which I did in a study. So we can do it, but it's tricky, and it's important to be very careful, I think, especially when we're talking about race, that we are precise and that we are identifying racial effects and not something else that's correlated with race. So and there is some good work, and I think it's increasing recently, and especially academics are starting to look at exactly what you're talking about, different parts of the process. Where might it come in, not just at the end stage in sentencing, but maybe at prosecutorial decisions, policing decisions, et cetera. And I think the body of good studies on that is starting to be built up, but a lot of earlier work kind of is more observational and doesn't account for the fact that race can often correlate with other factors. Now I will leave it to the rest of you to tell Jeff the answer to the hard question. What do you do with this?
I mean, you can try various debiasing techniques, right? So, make people aware of their unconscious biases. I mean, I think there's been some evidence that sometimes has some effect, but I don't know the literature very well.
Yeah, that's what I was going to say, is that some of the work that you cited, I think, is mostly from experimental, right? The implicit association test, and it really is a challenge to try to take that and put it into a more practical kind of field test to see what difference it makes. But my sense from the literature that's growing that making people more conscious rather than making it the culture of not talking about it is really the route to making some improvements. But I don't know of any field experiments that have tried to change a policy on that.
Maybe our colleagues in New York County will know about, wasn't there a Vera study having to do with charging decisions of women charged in New York County courts that I think the office did with Vera, that once the bias pattern was made clear to prosecutors, that dramatically shifted behavior. Do you know? Yeah, I think, Maddie, you remember.
I don't know if New York County, but Bureau has its whole unit on prosecution and race, and they've gone into a number of counties, including Milwaukee, but I think maybe...
I actually used to work at Vera in the prosecution and racial justice program, and so one way, you can do a study, a random assignment study, and you can find that, judges may be biased by race, but really sort of the techniques that are helpful for a local office trying to address bias that may exist within their office is for researchers to partner very closely in those offices and understand the process, because there are so many factors that could relate to the outcomes, to the various discretionary decisions, whether it's the initial charging decision or subsequent decisions in sort of charge level, and understanding the exact constraints of the office, the practice of the office, how much discretion there is at what point in the process is really important, because how you analyze something is very dependent on those factors, like within the office. And some of the findings point, as David mentioned, to other points in the process. So you'll see in some offices we worked in, we saw increase in declination to prosecute, in part because that pointed to sort of over-arrests by the police and racial profiling by the police. So I guess my point here is that if you really want to make a difference in how an office is managed and how discretion operates, you really need to, you can't just get a sort of data dump and then try and control for these factors. You actually have to really work in the office, work with prosecutors, understand how they're being managed. One policy recommendation that came out of some of our work was to put the more experienced prosecutors up front and have younger prosecutors learn from the more experienced prosecutors. So I think this partnering with researchers is important, but it's also important that it's not just give us your data and we'll run some regressions. It has to be an ongoing conversation, and you have to build that trust. So there has to be a trust that you're not out to get them, you're not going to expose them, so that they feel comfortable having these conversations, giving you the data, and then talking through what kind of policy changes would make a difference.
Thanks, Emily. That very informed answer, by the way, comes from Emily Turner, a Penn Law grad from not too long ago. Denise.
I'm Denise Fodoraro, and I just heard a story recently out of California from a friend of mine who was applying for a job as a deputy DA, and he kind of told me about some interesting questions that he was asked during the interview process. And that whole area might be something that we might want to look into, because it was just very enlightening. He was quite surprised. He was given the question, if you had a case where you were 50% sure that the guy was guilty, would you press charges? And he thought about that. And then the question was rephrased and said, if you were 65% sure, what would you do? If you were 85% sure? And he thought about this, and he answered his question. He says, well, if I were 50% sure, maybe not, but 85% sure, yes, and I'd leave it to the jury. And the supervising DA said, no, you do your homework, and you only press charges when you're 100% sure. So it was just interesting to kind of hear that process. And when he told me the story, it's kind of a window into what other questions, our interview questions, are interviewing DAs being asked. And you can take this for any of the other players in the criminal justice system, just to kind of see what priorities are being looked for. And it might be an interesting survey to... It's just a window into what the thinking and culture of what they're looking for in offices is like. So,
thanks. You want to comment?
Well, that actually it's fascinating. We did this conference in Stefanos was there at Cardozo Law School on Brady disclosure, and one of the most interesting moments is when Terry Moore, who was the first assistant from Craig Watkins' office, said that in making hires, they make it clear that if they catch you doing a deliberate Brady violation, they're going to fire you. So I think in a lot of these interviews, I've often been disturbed putting on my law professor hat for 34 years. I've never liked a lot of these interviewing procedures. I know that the various criminal defense lawyers' offices would ask questions of the prospective students that made it clear that only the craziest, most adversarial attitudes were acceptable to be a lawyer in the office. And some prosecutors' offices, but I think actually were better about that. Although there used to be the famous question that was asked always based on a New York case, what would you do if you found out that the complaining witness died, right? And the defense lawyer asked you about that, or the judge, would you give a weasel answer to make sure that you didn't inform them that the complaining witness died because that meant you didn't have a case again? It actually is quite fascinating to know what people ask and what criteria they're using for hiring. I myself personally believe that the criteria used on both sides is far too adversarial, far too directed at just fighting and not ends of justice, and that probably reflects a lot of the lack of communication that we have in the system as a whole. But that's just my opinion. But it was a very interesting moment.
Okay. I'm going to say we're slightly over time, so I'm going to say thank you very much to Barry and James for great, and the questioners for great questions. John Holloway is going to wrap things up.
So I think after a day and a half, my summary reaction would be, how awesome was that? I kind of went into this thinking, I don't know about the rest of you, but I know I'm going to learn a ton, and that's fundamentally my main goal. But it really has exceeded my expectations. So I want to thank all of our panelists, all of our moderators, and I want to thank all of you for coming and giving up a Friday and the first nice Saturday we've had in 9 months. I have a couple of other thank yous that I have to say, and in fact, it's been very nice for, I think, everybody who's stepped up to the microphone to thank me, as well as Frank and Denise. But the fact of the matter is, in terms of putting this on, we had the faculty staff of Anna, Debbie, Kristen, Nika, Jen, Kelly, Nisha, Silvana, and Michael. We had the communication staff. No, hang on. We had the communication staff of Lisa, Jordy, Rebecca, Emily, Steve, and Steve. We had the ITS staff of Dominic, Jason, Rick, Christine, Sudeshna, Emmett, and Chris. The facilities staff of Joe, and Gia. The development staff of Beth and Al. The business affairs staff of Ernie, Gerald, and Michelle. And the career planning staff of Becky. So thanking me is really thanking them. I want to take just 2 minutes before the end for the day to kind of summarize where I think we'd like to go from here. There's some themes that have come out of this that I think are extraordinarily valuable and that I think everybody can, I hope, use as takeaways to build on. The Quattrone Center very much aspires to be a convener or a hub of this kind of conversation. You can't have a good party without having great guests. And so I hope that you guys will come back to us with your takeaways as well, and that we can do this again and again and again. But I think, you know, the unifying theme of get the right guy in the right way is a very simple theme that I think everybody here agreed with for the entire day and a half. Getting there tends to be the challenge. But I think there were a few things that were mentioned that will really stay with me. One was the distinction of what I'm now going to start calling adverse events, because I think errors, mistakes, wrongful misconduct, all those things end up getting kind of politicized and twisted, and trying to find a vocabulary that we can use and agree upon where what we really talk about is making the fair administration of justice better from an objective, unbiased basis, I think has to be the goal. So I'm going to start using adverse events and recognize then that adverse events break down into misconduct and error, and that there are different approaches that we need to deploy to deal with each of those. What I heard from a lot of the systems guys yesterday was that actually we're going to have to keep dealing with misconduct. And I think the comments that were made in this panel in particular and some of the other panels about how we deal with incentives, how we reveal those incentives and deal with those incentives is extraordinarily important. But I also want to go back and say to the systems approach that says, actually, if you can deal with the errors, you will do two things. One is you'll reduce the errors. And the other is you will reduce opportunity for misconduct, which will reduce misconduct and make the resulting misconduct easier to sniff out. So there's some compound benefits from dealing with errors that I think is important to note. And both of them need to be dealt with, but we'll need to figure out different mechanisms to deal with them to make sure we're maximizing the fair administration of justice. The other theme that Lucian Leap said, two themes. One, if you don't measure, you don't know. So we've got to gather the data and measure it. But then to Barry and Sam's point, where's the data? We got to get the data. And there are going to be short-term experiments, short-term research projects that the Quattrone Center will do, that RAND will do, that lots of people will do. And hopefully that will begin to build the data. But the overreaching thing that we can do that's going to revolutionize the criminal justice system more than anything else is to actually start releasing this data and getting cross-jurisdictional data and multi-layered data from courts, prosecutors, and police, and defendants, and actually gathering that data into data sets that we can then analyze, because right now, we're behind on that. So I guess the thing I'd like to close on is, I was in this room on Monday, and there was a presentation from Angela Duckworth. Angela is a psychology professor at Penn who recently won a MacArthur Genius Grant for her research on grit. And what she's doing is sort of looking at successful people and trying to translate that into education and business and things for individuals, and the quality of that she's finding that unites and predicts success in individuals is this resilience or grit. And there are a couple of themes about it that, although she talks about individuals, I think might be worth looking at as far as the job that's in front of us as we try to improve the fair administration of justice. And so one of these examples is, I'm going to use two examples that deal with Usain Bolt in a different way. So Usain Bolt, as you guys know, is the Olympic sprinter. He's the fastest man on earth. When Usain Bolt, you watch him in the Olympics, and the last 30 meters of his 100-meter dash is just incredible because he just blows past these guys and takes the gold. What's interesting about that is that the reason that Usain Bolt is blowing past people in the last 30 meters is that his start suck, right? And so he's always behind. And so when Usain Bolt practices, he practices his starts much, much more than he practices his finishes. And I think as a system, we in criminal justice could learn something from that, because one of the things we've talked about here is learning from error, learning from adverse events, whatever you want to call them. But we need to work on our weaknesses. And that means we have to acknowledge our weaknesses. And that acknowledgement is actually a position of strength. When you're able to acknowledge your weaknesses, you're actually assuming a posture of strength and confidence that we're going to deal with this. And when prosecutors or defense attorneys step up and say something wrong happened in our office, when you hear Sean or Fran Healy say there are things that we haven't done right, when Commissioner Ramsey asks the Department of Justice to come in to look at whether his police are improperly using physical force, that's actually a position of strength. And I think more and more our community are realizing that, and they're beginning to support our public officials who get out ahead of those processes like Craig Watkins did and say, I'm going to establish a convictions integrity unit. I'm going to address this. This is something that I need to improve. I think we can all learn from that as far as something that we can do to build success over the long term with our endeavors. The second thing that I'd like to say is actually the Bolt metaphor kind of falls down with what we have to do, because it's not a sprint. It's a marathon. And we're not going to be able to go as fast as Usain Bolt for more than 100 meters, but one of the things that Angela Duckworth has found is that it's not the people who pull the all-nighters, and it's not the brief bursts of passionate energy. It's the everyday, sustained, long-term commitment of energy towards a single goal that's what's going to get us there. And a lot of people called this the first step, and I hope that's the case, right? I mean, I hope that, just like the airline industry, which started doing systems approaches in 1974, and now can say that they've reduced airplane crashes, 97% since that time. Like healthcare and Lucian Leap in 1998, which can look back and say, in 18 months we saved 122,000 lives. I hope we're standing here doing one of these in, I don't know how many, I hope it's next year, but I suspect it'll be a little bit longer, where we can look back and say, this was the first step, I was here, you guys were here, sustained effort, and we got it done. So I really appreciate your being here, helping us take this step. I look forward to having you here next year when we talk about the progress that we've made. And I look forward to going upstairs with you guys where we have box lunches, high tops, and beverages to keep the conversation going. Thanks a lot.